So the ATF just suffered another huge loss in the FRT challenge. The court here has denied the ATF's request for a stay of that decision, which struck down the rule. However, this fight is far from over, so we need to break down what is now happening. Now, before we jump into this video, I want to thank one of the new sponsors of the channel, which is Patriot Mobile. For 10 years, Patriot Mobile has been the only company in America, the only wireless provider that has Christian conservative values. Patriot Mobile offers dependable nationwide coverage, giving you the ability to access all three major networks. That means that the same coverage you would get from those companies is the exact same that you would get from Patriot Mobile. And you can also then support a company that has the same values as you, which is pro freedom of speech, pro 2A, and pro freedom. And also they are 100% based in the US, which means that if you need to call customer service, they're all here in the US, and I believe most of their team is actually in Texas. So I recommend that you guys check out Patriot Mobile. If you're interested, you can go to patriotmobile.com/scholar, or you can call 972-PATRIOT. Now, as I mentioned in the intro, in this video, we have some major news and updates in the battle against the ATF and their new restrictions and their rule on forced reset triggers. You may recall that earlier this year, we received some news that the lower court here, Judge O'Connor, issued a preliminary injunction which blocked the ATF's current attacks on forced reset triggers, or FRTs. But now that same judge, Judge O'Connor, has granted NAGR and Rare Breed and the other plaintiffs their motion for a summary judgment. That means that he reached a final merits decision, which ultimately struck down the entire FRT rule. Essentially, the ATF can no longer put in place their restrictions on FRTs, and essentially the judge here found that that ATF rule was unlawful and was in excess of their authority. That decision came in a case called NAGR versus Garland, but in response to that decision striking down the rule, the ATF asked for Judge O'Connor to place a stay on his entire decision and also put a stay or a halt on the requirement that they have to return all the items within 30 days, and then also send out a notice to everyone that this new FRT rule was struck down. Well, Judge O'Connor, in response to this, just denied the ATF's request for a stay, but some of the things did change in this case, and there's also going to be some changes that happen going forward, and some things that we need to talk about, which is now going to happen and how the ATF is going to respond. Now, for those not familiar with what's going on in this lawsuit, back in July 2021, the ATF sent out a cease and desist letter to companies like Rare Breed Triggers, and in that letter, the ATF claimed that in their eyes, the FRT-15, the forced reset triggers, these FRTs, actually meet the NFA and GCA's definition of a so-called machine gun. Now, in response to this notice and this new rule, Rare Breed then filed multiple lawsuits, but most recently, Rare Breed partnered with NAGR, and they filed a lawsuit in the Northern District of Texas, and that case was then assigned to Judge Reed O'Connor. And if you've been watching this channel for a long time, you know that Judge O'Connor out of Texas is an amazing judge. He's issued a lot of pro 2A decisions, a lot of decisions against the ATF, you know, in cases striking down their pistol brace rule, their unfinished frames receivers rule. So he's been very pro 2A, so it was awesome that this case was also assigned to Judge O'Connor. I also want to mention that there was a different lawsuit that also was going on, and that was in a federal court in New York, and that was decided against Rare Breed Triggers. But in the Texas lawsuit, Judge O'Connor originally granted the plaintiffs here a preliminary injunction. Now, in response to this granting of the first preliminary injunction, the ATF first sought a stay from Judge O'Connor, which was denied. And then again, they went to the Fifth Circuit. They sought a stay, which was also denied. And right now, the ATF is still appealing the preliminary injunction, and that's in front of a 3-judge panel in the Fifth Circuit. However, at the same time, NAGR and Rare Breed continued forward at the lower court level in front of Judge O'Connor, and they filed for a motion for summary judgment. Essentially, it's just a motion to not go to a full hearing, to have a case decided on the merits at an early stage. And on review, Judge O'Connor again sided with the Pro 2A side and struck down the entire ATF restrictions on FRTs. In reaching his decision, Judge O'Connor again relied on the analysis in the Cargill case, and then also used the recent Supreme Court decision, a 6-3 ruling in a case Cargill, and that was the Supreme Court affirming what the Fifth Circuit did in Cargill. And so there, what happened is Judge O'Connor used that recent Supreme Court decision to again find that these types of triggers are not machine guns and that the ATF engaged in overreach. So we all knew that the Cargill decision would have important trickle-down impacts on a ton of ATF cases, and this is one of the first ones because, again, it deals with an item trying to be defined as a machine gun, and so the Cargill case was used in the FRT case. And then he goes on to say because of that, because of the ATF stepping in early and not letting Congress essentially decide if they were going to enact a law or change the statute, the ATF took all the attention, took all the action on their own, legislated on their own, and then regulated these items, which is not within their powers. And based on all of that, what he did is he vacated the ATF's classification of FRTs as machine guns and declared that the ATF's determination of FRTs as machine guns was in fact unlawful. And as a result of that decision, he enjoined the ATF from enforcing the restrictions against all the plaintiffs, the organizational plaintiffs, their members, any customers of all those companies, as long as the injunction here, as long as what he did in joining this did not impact the ruling that happened in New York. Now, out of that decision, Judge O'Connor also ordered 2 obligations of the ATF that they had to meet. The first order essentially was that the ATF had to return all 11,000 FRTs that they confiscated, and they had to return those items within 30 days of that decision. And then also he said that they needed to send out a legal notice to all individuals involved that the ATF's rule was in fact invalid and has been found invalid. Now, the ATF argued in their stay request that both of those obligations were essentially impossible for them to meet within 30 days. They stated that they could not return all 11,000 FRTs only within 30 days. And then they also said that there is no way of them to know all the members and all the individuals that they needed to return these items to or to contact. They also argued that the notice requirement to the public would cause confusion. There would be a lot of legal confusion if they appealed and maybe got a stay from the higher court or if something changed. But in response to that, Judge O'Connor has recently issued his decision denying the ATF's request for this stay. But in response to those arguments, Judge O'Connor denied the stay, finding that they were not persuasive. And in response to the whole notice argument, he stated that defendants argue that potential confusion can occur from the remedial mail notices. Again, this is fundamentally tied to the merits. If, as this court has ruled, FRTs are not machine guns, then informing people about the ATF's erroneous rule is not an irreparable harm, but an affirmative good to inform the public who have already received false information from the ATF. In contrast, plaintiffs would be substantially injured by a stay. The court has already found twice in slightly different contexts that plaintiffs face a substantial risk of irreparable harm if defendants are not enjoined from engaging in enforcement activities. So he said that there would be no harm from sending out this notice, that it's actually in the public's benefit to have notice that the ATF's rule has been struck down. However, when it came to the 30-day return of all those items, that obligation, the ATF argued that they could simply not do that within 30 days, and Judge O'Connor in some ways found in their favor. What he said is, no, I'm not going to grant you a stay of my entire decision, but I will give you an extension. He said that an extension of time is the appropriate form of relief. Granting a blanket stay on his decision is not valid. And so what he decided to do instead is extend it out and give the ATF 6 months to comply with his order. So the ATF has 6 months to return all of those 11,000 FRTs. And so that gives them until February 22nd of 2025 to return all of those items. Now, again, when it comes into the context of this case, no doubt the ATF is going to seek a stay from the Fifth Circuit. They're going to file an appeal, and then they're also going to seek an immediate stay from the Fifth Circuit. But remember, the Fifth Circuit has already denied a stay when it came to the preliminary injunction in this same case. And so there's already an appeal going on with the preliminary injunction, but I would suspect that that would be found kind of moot. And then the main merits decision here, the motion for summary judgment, that's what's going to move forward towards the Fifth Circuit. But what I would also anticipate is if the Fifth Circuit also denies the stay on this merits decision, I would then suspect that the ATF is probably going to go to the Supreme Court on an emergency basis. We saw them do this with the Vanderstock case when it came to the unfinished frames and receivers issue, and twice when it came on an emergency basis, the Supreme Court actually sided with the ATF. So here the ATF could say, or at least think in their minds, that maybe they would have a chance in front of the Supreme Court. But I would say in some ways the ATF probably has hesitation to do that because this case, the FRT issue, deals directly with Cargill and what the Supreme Court just said in Cargill. And because of that, it is not a just open and shut case that the Supreme Court is going to grant them an emergency stay. So the ATF might have second thoughts about doing that, but that is an avenue that the ATF has done before. In these types of cases, they've won before in the Supreme Court on an emergency basis for a stay of this type. And so I would suspect that the ATF might go down that route as well. But overall, this was a huge win. It was a great win. Again, Judge O'Connor denying the ATF stay, and now this case is going to proceed forward at the Fifth Circuit level, and the ATF is probably going to seek a stay from the Fifth Circuit, and we're going to have to see how that plays out if the ATF decides then to go to the Supreme Court on an emergency basis to try to get a halt on this entire vacature. So that's what's currently going on in this ATF overreach case. If anything else changes, if anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget that this nation was built by armed scholars, and this nation will be maintained by armed scholars.